Good morning, everyone, and welcome to this webinar with the Spain-US Chamber of Commerce about the ABCs of doing business in Florida, and specifically the employment law perspective. But before we start and I introduce you our speakers for today, I just want to remind everyone about all the events that we are hosting at the Spain-US Chamber of Commerce. Not only webinars like this one that we try to host at least 1 or 2 per week, but also in-person events that we host during the year. So in order to find all the events that we are hosting, please check our website, which is www.spainuschamber.com. And you will find there all the activities that we are hosting and some information about the Spain-US Chamber of Commerce. About the webinar today, some things important. We will dedicate some time at the end of the presentation for Q&A. So any questions that you might have, we will address all of them at the end of the presentation. But you are more than welcome to send those questions during the presentation at any time. So you don't need to wait until the end to send those questions. And in order to get those from you, the only thing you need to do is click on the control panel that you might be able to find probably on the right side of your screen, the Go to Webinar control panel, and find the question tab. You just need to click there and write the question, and we will address all of them at the end of the presentation. Also, this presentation in this webinar will be recorded, and we will share the recording with all the attendees. And also we will upload the presentation and the video to our YouTube channel. And if you like, you can check in our YouTube channel all the other incredible presentations that we've been hosting in the past years, addressing many different topics that I'm sure that you will find very interesting. And finally, the presentation that will be shared with all the attendees. So everything that we will see today will be also shared with the attendees, so that you might be able to get not only the information, but also the contact information of the 2 panelists that today will join us and will address any question that you might have. And without further ado, I would like to thank Littler to join us in order to, shed some light about the employment law perspective. And for those of you that don't know Littler, they are the largest law practice in the world, exclusively devoted to representative management in employment, employee benefits, and labor law matters. So I think we have the right partner for this specific topic. And to talk about this, we have 2 great lawyers, attorneys that will discuss this with details. We have Juan Carlos Varela, Office Managing Shareholder. Juan Carlos is an international attorney, licensed and admitted to practice before the courts in Venezuela, Colombia, and Florida. He focuses his practice on representing and advising global clients on matters throughout Latin America and the Caribbean, involving labor and employment law, litigation, international arbitration and alternative dispute resolution, and global investigations and audits. Welcome, Juan Carlos. And we also have with us today, Rocio Blanco Garcia, Associate. Rocio is an attorney at law and counsels and represents clients in a broad range of labor and employment matters. She has handled cases before state and federal courts and before administrative agencies, including the Equal Employment Opportunity Commission and the Florida Commission on Human Relations. Before joining Littler, Rocio was a senior assistant county attorney with the Broward County Office of the County Attorney, where she represented Florida's 2nd largest county in harassment and discrimination matters and labor proceedings. Welcome, Rocio. And Without further ado, let's dive in this interesting topic that I think will be very useful for not only companies interested in establishing operations in the United States, but also companies that are already here, and they might not know that maybe they are not completely in compliance with all the regulations. So thank you so much, everyone, for joining the Spain US Chamber and Lidler this morning. And Rocio, I leave the floor to you.
Thank you so much, Juan Carlos, and thank you everyone for your time this morning. I speak for both Juan Carlos and myself when I say we are overjoyed to be here with you today and to give you an introduction of what we do on a day-to-day basis. I say we're going to give you an introduction because the world of labor and employment, it's rather large, right? Like we could be talking about each of these laws for days and days, but obviously we only have 1 hour with you this morning. And so our focus is going to be introducing key topics so that you can get a flavor for this world of employment law, and it can hopefully trigger some questions in your mind as to what you should be doing if you're establishing a business, or whether you are doing the correct things already if you are already established, whether it's in Florida or elsewhere in the United States. So we're going to focus on 10 things that employers should know about doing business in Florida. And when I say in Florida, some of it overlaps with other states as well. And then as part of our Q&A, I know Juan Carlos is also planning to touch on the issue of managing the business from Florida to the Americas, right? So to the extent that you have operations in different areas of the Americas, how do you manage that business from Florida? So jumping right into the issue of employment law. So this is something that I do day in, day out. It's my bread and butter. And the main thing I can share with you is that there are a multitude of federal employment laws that govern the employer-employee relationship. And here I have put some of those laws, like Fair Labor Standards Act. Well, that's going to tell you how much do you have to pay your employees, and also whether you have to pay them as salaried employees or hourly employees. Oftentimes, I, for example, grew up in Spain. We think of the relationship with employees, there being a contract that sets forth a salary that the employee is going to be paid on a monthly basis. That is not usually how things work in the United States. In the United States, you cannot be salaried. You have to be an hourly employee in most cases, unless you meet certain criteria. So to the extent that any of you are paying your employees on a salary basis, you have to ask yourselves, well, is that the appropriate thing to do for this particular employee? Equal Pay Act. So that sets forth requirements for paying people the same if they are engaged in the same type of activity. These are designed to avoid things like women making less money than males. Title VII, that is concerned with discrimination on the basis of race, gender, national origin, religion, and several other protected categories. Age Discrimination Employment Act. Well, here in the United States, age 40 is considered a protected category. So what you will learn today, briefly, and later on, if you inquire in greater detail, is that we cannot treat people less favorably just because they are over the age of 40. And the reason why this law was put into place is because there was this stigma that as employees got older, they became less agile or less effective or less, efficient, and they were being replaced with younger employees. So to avoid that, the Age Discrimination Employment Act was enacted. Occupational Safety and Health Act, that's also known as OSHA, and that sets forth the requirements that each of your plants, each of your facilities must follow in order to ensure the safety of your employees. OSHA played a very prominent role during COVID-19, but just generally speaking, even without COVID-19 being at the forefront of our news every day, OSHA still plays a very important role, and it is important that you be familiar with what is required of you as an employer to make sure that you are keeping and maintaining the safety of your employees. The Americans with Disabilities Act. That is a law that you also must follow that basically requires you to accommodate employees who have certain disabilities. And oftentimes employees make mistakes because they think like, well, that's employers make mistake because they think, well, that's not really a disability, or, I think they're faking it. And that is not something that you can do. You have to be consulting with your human resources. You have to be consulting with your counsel to make sure that you are following the appropriate protocols when it comes to the Americans with Disabilities Act. And the same is true of the Family Medical Leave Act, also known as FMLA. That is a law that gives employees who have been working for the company for at least 1 year and who have worked at least 1,250 hours entitlement to 12 weeks off of job protected leave unpaid for certain conditions, like, for example, the birth of a child. So in the United States, unlike in some of our countries, and I'll go back to the example of Spain, we don't really have maternity leave. We don't really have paternity leave. What we have is the FMLA, and that just means 12 weeks of job protected leave that it's unpaid. Some companies provide greater benefits, and in some states, you have to provide greater benefits. But when it comes to Florida, all you have to provide your employees is 12 weeks of unpaid leave for certain conditions, including the birth of a child. Now, I just mentioned in some states, right? And the reason why I say that, like, emphasize that point, is because in the United States, you have to think of the United States as 50 countries, almost like 50 mini countries that came together. Each state has its own set of laws, and each state has its own set of employment laws. So we cannot just be looking at what is the federal government requiring. We also have to look at what is each state requiring. And the good news for those of you who are doing business in Florida is that Florida is a very employer-friendly state. So if you compare Florida with states like New York or California, you will find that we have fewer regulations and fewer requirements on employers. But don't assume that what you hear today will apply in every single state in the United States, because it will not. Different states will have their own sets of laws as well. Now, one important point that I also find that employers who come from other countries and try to establish business in Florida or elsewhere are not familiar with is the concept of employment at will. Earlier on, I discussed how, for example, in Spain, right, like you will have a contract with your employee and it will be like, well, it's an annual contract, and then at the end of the year, we renew it or we don't. Here, it doesn't work like that. Here, the majority of the employment relationships are what we call an employment at will. What that means is that you, as the employer, can discharge or terminate that employee at any time for any reason, good or bad, and that the employee can leave the employment at any time for any reason, good or bad. So now you might be wondering, hold on. So are you telling me that I might be hiring, so and so, and then on Monday they decide that that's it, that they don't want to work with me anymore and they leave me hanging? Yes, that is the reality of the employment relationship. But the good thing is that you too don't have to stick around with an employee who you do not like. You can just terminate that employee at any time. Now, when I say for any reason, good or bad, that is a general term. The reason, though, must not be unlawful. So, for example, earlier on, I mentioned Title VII and how that law prohibits discrimination on the basis of race, gender, national origin, and a few other protected categories. So you can fire an employee for any reason that you want, but it cannot be because they're Black or because they are Hispanic or because they are older. That would not be a lawful reason. But you can fire them because you don't like them, or you can fire them because you don't get along with them, or you can fire them because they eat too loudly, like at lunchtime. Like, you can have any other reason as long as it is not an unlawful reason. So that is something that, if you are trying to hire people in the US or in Florida, I will encourage you to not do a contract. you want to take advantage of the employment at will, so that if the employee is not working out, you just go ahead and you fire him and you get or her, and you get a new employee. I would not come in with the mindset of having to do a contract like you do in many other countries. Now, of course, when you're hiring an employee, there are certain things that we gotta keep in mind as well. So we want you to, as an employer, to cast a wide recruiting net to decrease the risk of appearance of discrimination. So what you will find is that in the US, it's all about, are you discriminating or are you not? If you're not, you're likely good. But of course, you want to make sure that you're writing your job posting in a way that is not discriminatory. For example, if I write in my job description that I'm gonna post on Indeed or in whatever online portal, looking for a young and agile male to work in the stocking the shelves of the facility. Well, that is a discriminatory job posting because you're saying you're looking for somebody who's young, who's agile, and who's a male. So you're already getting rid of potential candidates who might be older and still be qualified for the job, or who might be females and still qualified for the job. So you want to make sure that when you're looking at how you're writing the job posting, that you're using neutral language so that it doesn't create the appearance of discrimination. You also need to be mindful that some jurisdictions will prohibit you from asking about the salary. So what were you making in your prior position, or what do you want to make in this particular position? And some states will even require you to post the salary in the job posting. Okay, so that is one way in which things change from state to state. When you have posted the job, you have gotten some applicants on the door, and now you are interviewing those individuals. Well, some things should not be asked. You should not be asking people whether they're married, whether they have children, how old they are, where do you come from. Those are questions that here in the US, we do not want you to be asking as part of the interview process, because that is knowledge that once you acquire can be used to say, well, you were discriminating. You didn't hire me because I told you that I come from, I don't know, Zambia, or you didn't hire me because I told you that I have 3 children, and that created the perception that maybe I do not have the capacity to both manage my family life and my work life. So be careful when you are interviewing to not get so comfortable that you start asking personal questions that really should not matter for purposes of the job. Whether I have 3 children or I have none or I have 10 should not matter to whether I am able to do the job or not. Some people have different management skills, some people organize their lives differently, and I might still be as great of a candidate as somebody who has no children, right? So it's very important that we do not ask questions that may give reasons for a candidate to then say, you did not hire me because you were discriminating against me for being a woman or for being Hispanic or for being Black or for my religion, any of those things. Now, mental and physical examinations. Mental and physical examinations can be done as part of the hiring process, but typically you will only be able to do it after the person has had an offer of employment. So basically, you offer the job contingent on the mental or physical examination. And usually, the mental and physical examination, you will only do it for jobs where that matters. So, for example, let's say that you're going to be a truck driver, right? A physical examination or a sleep study, for example, might be important because we want to make sure that our truck drivers are not falling asleep on the road. But for example, for somebody like myself, who's a lawyer, I'm probably not going to be required to do a mental or physical examination before I get a job. Now, I-9 and work authorization issues, those are immigration issues. So you want to make sure that you are hiring people who are able to work in the United States, whether it is through a visa or through some other work authorization. And you are going to be required to comply with laws that require you to ask for specific documentation from candidates in order for them to be able to work. And that's also something that you will do post offer. Now, and keeping records. So we need to make sure that we're not just like, so if you could see right now my desk at home, you will see that I have papers everywhere. That's not how we want you to keep records, right? Like these are papers that I use in my day to day, but we want to make sure that you have like files and that everything is well organized, because if there were to be an audit by the Department of Labor of how you're paying your employees or how you're classifying your employees, you want to make sure that you have good record keeping. Otherwise, you might be found to not be in compliance. So make sure that you are also very organized with the way you're managing your business. Okay, drug and alcohol test. And the recent craze over medical marijuana. So, medical marijuana has been legalized in a lot of different states, and some states have even allowed for recreational marijuana. That does not mean that you yourself need to hire. You can have a policy that still says that you would not hire anybody who tests positive for marijuana. That is still okay. So, just because it is illegal, it doesn't mean that you have to hire those people. You can choose to still not hire people who test positive for marijuana if that is your business judgment. Now, criminal history checks. So criminal history checks, you just have to be careful and look not only at your particular state where you're operating, but you're also going to want to look at the particular county where your business is at. So, for example, Broward County has a banned box, which means that we don't ask you about your criminal history as part of the initial application process. And many other jurisdictions also have that. So just be careful that you are consulting with lawyers or with your human resources department as to what it is that you can ask in the different counties and in the different states where you operate. Fair Credit Reporting Act. So when you run a background check, it has to be limited to 7 years, and there are certain things that cannot be reported and that cannot be the basis for your hiring decisions. So make sure that you're partnering with a background company that is reputable and that that has done its due diligence, so that you can feel comfort and trust in the documents that you're getting back from that company. And then reference checks, obviously, that's something that you can do. But when you're doing your reference checks, also be mindful of what questions you're asking of those references to make sure that they are appropriate and that they do not lead to a conclusion that perhaps you may have been discriminatory. And then social media, I feel can be a tricky one. So it's okay to look at social media and find out more about your candidates, but also be mindful of how what you find there might impact you, right? Because if I go on social media and now I see that on Sundays, you're always at church on Sundays, but I'm myself, I'm an atheist, and I don't agree with people who go to church. Now am I making my hiring decision? Am I choosing not to hire you because you are religious? Because that will be discriminatory. So be mindful that, yeah, you can check social media, but are you going to be making decisions based on what you find on social media? And if so, is it going to be a protected category that may get you in trouble? So be mindful of those things. And why do you have to be mindful? Well, let's go back to the topic of discrimination and harassment. We are in Florida, especially, a very what I call like easy state for employers. We do not have a ton of regulations, but we still are subject to the federal laws. And the federal laws prohibit discrimination and harassment. So every decision that you make as an employer has to be based on what we call legitimate business reasons. So you cannot choose not to hire, choose not to promote, choose not to include in events people because of their gender, their sex, whether they're pregnant, their race, their ancestry, their color, their religion, their age. Those are all protected categories. So you cannot treat two people who are similarly situated differently based on one of these categories. Okay. So for example, my colleague Juan Carlos and I, let's say that we're both applying for a job. It is totally okay for you to hire him and not me based on the fact that maybe his past experience aligns better with what you're looking for in the position. Or you may hire him because of the school he went to, because you find that that is a more prestigious school, or because he's licensed in more states than I am. Those are all legitimate business reasons to hire Juan Carlos over me. But you cannot decide that, you know what, Rocio and Juan Carlos are about the same. I'm gonna go with Juan Carlos because he's a male, and I don't like female drama. Let's say that that is one of your prejudices, right? So you want to make sure that you are not making discriminatory decisions anywhere in the employment relationship. So not just the hiring, but once you are hired, the promotional opportunities, what you get included into and what you don't get included into, the training opportunities that we give people, everything has to be based on legitimate, non-discriminatory reasons. And the same goes for harassment. Oftentimes we spend a lot of time with our employees, we spend a lot of time with our colleagues, we eat lunch together, and we develop friendships. Some of us develop romantic relationships at work. Like, we get very close to the people we work with, and because we get close, we tend to get comfortable, and then we start making jokes. And so we need to be very careful with what jokes we're allowing in the workplace, because that those can be seen as discriminatory or harassing. For example, let's say that I, that Juan Carlos and I are eating lunch, and in comes in our coworker who's much older than us, and Juan Carlos and I start being like, "Come on, old man, are you still here? When are you gonna retire?" And maybe we're saying it just as a joke, like, like, you deserve to just stop working now. But that can be seen as harassing, that can be seen as discriminatory. So we need to make sure that we as employers have policies in place that target that behavior, and that our employees are trained on what jokes are appropriate and what jokes are not, that our employees are trained on what behavior is okay and what behavior is not. Talking too close to people, touching them on the shoulder while they're talking to you, asking them out on a date, and after they say no, you keep asking. Those are all forms of harassment that we need to make sure that we're prohibiting in the workplace. And it is important for us to remember that it is not just within the four walls of the office that we need to prohibit these things. But let's say we go to happy hour. You're still with your coworkers. You're still with your peers. So we need to make sure that those same behaviors that we wouldn't allow within the four walls of the office, we also don't allow them on happy hour. Happy hour does not become a free for all. So we have to be very careful with our behavior also outside of the office, and how that behavior may impact the inner workings of the workplace. Holiday parties, they are great for disasters. People drink, they get comfortable, then they start making comments that they wouldn't make in the absence of alcohol, things like that. Those are all situations that tend to lead to harassment complaints. So just be very careful that you are reminding your employees of what's expected of them from a behavior standpoint, and how it applies both within and outside of the workplace. Another thing that you have to be mindful of as an employer is that you have an obligation to accommodate employees who have disabilities. So if one of your employees is disabled and gives you enough information for you to know that they might require an accommodation, you need to engage in what we call an interactive process, where you ask questions of the employee that will allow you to determine how that employee can be accommodated so that he or she can continue to do the essential functions of their job. It may be something as simple as like an ergonomic chair or a standing desk, but sometimes it may be something a little bit more complicated, like an alternate work schedule or, you know, maybe create a phone device that allows you that has certain tools for people who are hearing impaired. So you just need to make sure that if you are on notice that an employee may need an accommodation, that you engage in that interactive process so that you can provide the accommodation that is needed for the employee to do the job. The only way that you don't have to provide accommodation is if the accommodation will be an undue hardship. And we could talk about this for days, but basically you have to make sure that you document everything appropriately so that if you were to be sued for not accommodating an employee, you can show, well, this is the reason why I did not provide that accommodation. It was incredibly expensive. It would have been disruptive of the workplace. It created a safety issue. You want to have all those reasons documented. And you also have to accommodate religious practices. Now, this one, it, there's a lot to be said here. Like, it doesn't, so you typically want to accommodate religious practices, but for example, let's say that you have a union, right? Like, the religious practice is not gonna trump the seniority and the rights that come with seniority within the union, and things like that. So, but just be mindful that that is something also that you might need to do as well, accommodate a religious practice. So when we're talking about disability, remember, we're talking not just about a physical disability, but also a mental impairment. So stress, anxiety, suicidal thoughts, these are all disabilities that we might need to accommodate as an employer. So don't, and you have to have an open mind. You want to think of, like, some people have preconceived notions of like depression or anxiety. You as an employer cannot come into the workplace with those preconceived notions. It is important that you have an open mind and that you listen to your employees so that you can provide the accommodation that's required. It will be a big mistake for you to say, for an employee to come to you because they feel they need an accommodation and you say something like, we don't do that here, or well, depression, come on, that's not a real thing. Like that, those dismissive comments would be very detrimental to you as an employer. So we want you to stay away from doing that. Let the doctors decide what's a disability or not. Your job is only to engage in the interactive process, to ask the questions that need to be asked, and to provide the employee with information. Okay. I'm gonna skip ahead 1 second. Okay, retaliation. So let's talk about retaliation. If an employee comes to you and says, hey, I think I'm being bullied because I'm Black, or I think I am being paid less because I'm a woman, or I think that, my boss is picking on me because I'm pregnant, that complaint, that is a protected activity. So the employees have a right to come to HR, to their supervisors, to management, to complain about what they perceive as discrimination or harassment. And what you as an employer cannot do is retaliate. So if somebody comes to you and complains, you cannot now uh, demote them, fire them, be dismissive of that complaint. To the contrary, you have to investigate. So we want you to partner with your HR or with your legal department to investigate complaints of discrimination and of harassment, and to make sure that everyone knows that you cannot retaliate because somebody has complained. We might feel like, oh, there she goes. She's a troublemaker. She's always complaining. But that is not the appropriate way to handle the situation as an employer. You want to investigate in a neutral manner and then reach a conclusion as to whether the complaint had merit to it or not. But you cannot discriminate against, you cannot retaliate against the employee who is complaining. It is important that you engage in prompt and thorough investigation. if there is a complaint, and that you provide prompt and effective remedial action. So if somebody comes to you and complains about their supervisor, if there is merit to that complaint, it's going to be very important that you act expeditiously to remedy the situation. And one of the main ways that you as an employer can prevent these type of things from happening in the workplace, from there to be that you can prevent discrimination or harassment in the workplace, is by making sure that you're training your employees regularly. Our employees don't know what they don't know. So it is on us as the employers to make sure that they are aware of what is considered sexual harassment, what jokes are appropriate and what jokes aren't appropriate. We want to provide that training to our employees so that we can maintain a harmonious workplace for everybody. And this matters from a financial standpoint. If you get sued, if somebody files a lawsuit against you for employment discrimination, and that person wins and that person is successful, they're gonna get their money, like the money that they will have earned had they continue working with you. They can get emotional distress damages, so for the mental turmoil that they have had to go through as a result of the termination or of the discrimination. And you also will be responsible for paying their lawyer fees. You may also be responsible for punitive damages. Those are capped at $300,000 for employers that have 500 plus employees, and at $100,000 for employees below that. And in Florida, they're capped at $100,000, period. But the lawsuit may be in Florida or may be in federal court, so it depends, right? So it can be very, very expensive to be sued for one of these things. And not only that, if you yourself also have a lawyer, then you also have to pay your own lawyer fees on top of that. So it is very important that we invest in the future, that we invest in these mitigation techniques so that we can avoid these lawsuits, because they can become very, very costly. Now, earlier I mentioned that it is important that you remember when an employee is exempt or is not exempt. In our countries, or in the country I come from, we tend to just have this contract, right? I get paid a salary. That is not how it works here. It is super important that you classify your employees appropriately. And if they are not considered salaried employees under the law, you cannot pay them a salary. They are entitled to an hourly wage and to overtime for every hour above 40 that they work in any given week. And if we mess that up, then there's financial repercussions, because the law requires us then at that point to pay them the wages that we didn't pay them, requires us to pay them double that amount as what we call liquidated damages, and then we also have to pay their lawyers. So it is very, very important that we classify employees correctly. You don't make an employee exempt from the rules simply because you call him a salaried employee. And the job title is really not going to matter. You can come up with a fancy job title. That does not make the employee an exempt employee. What we care about is what are their duties, what are they doing on a day-to-day basis. That is what's going to determine whether that employee has to be paid hourly or as a salary. Okay. So for example, a paralegal typically will actually get paid as an hourly employee, but a lot of people think they just get a salary. So don't assume. Partner with a vendor, a lawyer, human resources, to make sure that you're classifying your employees appropriately, because there is serious risk if you are not. Okay, let me skip ahead. So family and medical leave. This is something I introduced at the beginning of our conversation, and I'm skipping ahead a little bit because I know we're running out of time, and I want to make sure that we have appropriate time for questions. But as I mentioned, unlike in other countries, here in the US, we do not have this concept of maternity leave that you go away for 6 months and your employer pays you. That's not really how it works in the US. In some states like California, like New York, there are certain forms of paid leave, But generally speaking, and specifically as to Florida, all you get is 12 work weeks unpaid. So you go away for 12 weeks, you're not making a penny, and then you come back and your job is there waiting for you. Um, so to the extent that you are an employer who wants to provide more benefits, you can do so, but you're not required to, at least in Florida. Now, one important thing to remember is that if you are subject to the Family and Medical Leave Act, and that only applies to employers that have more than 50 employees in a 75-mile radius, you have to provide the leave to an employee who is entitled to it, and it doesn't matter how inconvenient it is. So if you are now feeling like, well, I cannot afford for Rocio to go on leave for 12 weeks because who's going to be handling the phones or who's going to be dealing with the customers, well, that's your problem as the manager. You need to make sure that you have enough employees so that if one of them has to go on leave, they can go on leave, because the law does not care that it is not convenient to you. You have to provide that leave to the employee if the employee is entitled to it. And there are other forms of leave as well, military leave, and under certain circumstances, under the Americans with Disabilities Act, your obligation to accommodate the employee may also require you to provide some form of leave. Now, this is a lot of detail. You don't have to remember all of this, but generally speaking, the FMLA, as I just said, only applies to employers that have more than 50 employees within a 75-mile radius. The employee must have worked for the company for at least 12 months and must have worked at least 1,250 hours. If they do not meet that criteria, then they're not entitled to leave, generally speaking, in Florida. And so that could really mean that, let's say I just started working for you 3 months ago and now I have a baby. I have my baby on Friday and I have to come back to work on Monday. That's just the law here. Okay. Because at that point, I would not have worked for you for enough time for me to be entitled to FMLA. And I keep mentioning birth of a child, but there are other reasons for why an employee may also be entitled to leave. That could be that they are very ill themselves, that a parent is very ill, that a child under 18 is very ill, or also, for example, that they have a family member who is in the military and is called to active duty, and now they have to take care of that service member. So those are all forms of or those are all reasons why you may be entitled to FMLA. Now, we are reaching almost the end here, but another important thing is a lot of times employers do not want employees to talking about salary. And that is not something that here in the US we can prohibit. So for example, if you find two employees in the break room, in the kitchen, discussing their salaries and how, they are upset that so and so is making more than them, you cannot discipline them for that, because that is what's considered protected activity under the National Labor Relations Act. So employees are allowed to engage in discussions concerning things like salary, the terms and conditions of their employment, and we cannot, as employers, prohibit them from doing so simply because we do not like what they're discussing. So these are all examples of what's considered protected activity under the National Labor Relations Act. And we need to allow each of these things to happen in the workplace if they're happening, right? So don't be upset if you find two employees discussing mismanagement by a supervisor or a manager, or you can be upset by it, but you cannot discipline employees for it. Okay, workplace safety. So as I mentioned, you are subject as a private employer, or you are subject to OSHA. So you have to have a safe workplace for your employees. You have to comply with certain health standards, particularly after COVID-19. You have certain duties with respect to recording and reporting injuries in the workplace. And you also have to make sure that you are following workers' compensation and state law requirements. So you should all have workers' compensation so that if an employee gets hurt at work, that employee can be compensated or can receive the medical treatment needed for that workplace injury. Now, with respect to safety in the workplace, Florida is a very pro-gun state, which I know a lot of people have strong feelings about. So you can actually not prohibit your employees from having a gun in the parking lot. So you can tell your employees that they cannot bring a gun inside the actual workplace, but they can still have one in the parking lot in their cars. And I know that that is very counterintuitive, and a lot of people disagree with it, but it's the law in Florida. All right, employment agreements. When you are making your employment agreements, you should partner with a lawyer, at least for the first couple of them, to make sure that you're using the correct language. There has been a lot of changes in the law in the last 2 months regarding non-competes, non-solicitation, and confidentiality agreements. So this is actually a very evolving area of the law. So just make sure that you partner with somebody who has the knowledge and skill to help you draft a good, compliant employment agreement if you are ever going to have an employment agreement. Remember, we discussed that employment is at will in the United States, and in Florida. But for example, high-level sales executives, we will sometimes have an employment agreement for C-suite employees too. So before you draft those employment agreements, just make sure that you're partnering with somebody who can really help you understand what's allowed and what's not allowed. And if you are ever having to terminate an employee, you just need to make sure that you pay them for every hour work. In Florida, you do not have to pay them for unused vacation. Um, and you want to make sure that you comply with any applicable laws regarding insurance information, and things like that. All these requirements are going to change from state to state, but Florida is very easy in that sense that all you have to do is just basically pay the employee for the hours that they worked, and make sure that you send them what we call a COBRA letter, which deals with their employee benefits. And then release and waiver agreements, that's another area of the law that's evolving very much. So much like with employment agreements, just make sure that you're partnering with somebody so that if you are going to have an employee sign a release and a waiver, that you are doing it in a way that it is compliant. All right, I think it's time for the questions. And again, this was just a preview. There's like a ton more to talk about, but we just wanted to give you an introduction of some of the laws that you have to be mindful of.
Thank you so much, Rocio. That was amazing. How do you organize all the information in a nutshell? And I know that that's a lot of process, but I think a lot of important issues have been brought up. So thank you so much. Anyone that would like to ask any questions, please send those questions right now through the questions tab that you will find on the control panel on the right side of your screen. And just write the question, and we will address all of them. As a reminder, meanwhile people are sending their questions, we already have some of them, but as a reminder, we are going to share the presentation with all the attendees, and we will share the video, and it will be also uploaded to our YouTube channel, so anyone could share that video with your friends and colleagues that might be interested in these topics. And also you can see right there in the screen now the contact information of Rocio and Juan Carlos. There you can see their email addresses, and we will keep this screen during the duration of this presentation, so that anyone would like to send any email specifically or directly to them, you can do so. So let's go and jump to some of the questions that we got. First question is related to the exempt. What it is exactly exempt that you mentioned before in the presentation?
Yes, so an exempt employee, there's two components. They have to make a minimum salary, which I believe is in the $40,000 range. But I will have to double check that. And then there's also what's called a duties test. So they have to be performing tasks that are specialized in some way. So for example, when you have an employee who is merely, transporting items from your warehouse to, to customers, that person is not going to meet the duties test. So you have to look at each position, uh, one by one, to make sure that they're doing the type of work that the law considers to be exempt. And that's going to change, from job position to job position. So we will have to literally analyze the particular job description that you have for that particular employee. But generally speaking, that's what you need. One, they need to make a minimum amount of money, and two, they need to have some specialized duties, not just like your run of them. Like most of your employees will typically be hourly employees.
So then if those employees doesn't meet those criteria that you mentioned, the minimum amount and the duties, they will be considered a non-exempt, and then the employer should pay them by the hour. That's correct?
Correct. They have to pay them the minimum, at least the minimum wage,
Mhm.
and they also have to pay them overtime. So when you work more than 40 hours per week, now you have to pay that employee time and a half. Um, so that's why the classification is so important, because if you misclassify somebody as salaried, then you are cheating them out of time that they should have gotten paid extra.
Okay. And one question about that. What's the minimum wage in Florida for hourly employees?
So that has been, it's expected to reach $15, I think, in the next year. I think right now is 12 something an hour.
Okay. Well, thank you. Thank you so much for that, Rocio.
But you also have to
Um,
look, sorry to interrupt. You have to look
yeah.
also to the specific county and sometimes a specific city that they have different minimum wage. So it's not the Florida in general. So if you are located in a specific place, you have to look at the minimum wage of that specific county. So it varies.
Yeah, it's complicated, guys. It's like you are dealing with like so many different laws, right? Like think of it like a pyramid. You have federal, you have a state, and then you have each individual county. And so, for example, Florida, I just double checked, it's $11 an hour. It's increasing to 12 on September 30th of this year. But if you are doing business in Broward, for example, there might be a minimum wage for people who are doing business in Broward that might be higher. So you cannot just go by the state, like Juan Carlos just said.
And one interruption before we go with the additional questions from Carlos
Yeah.
is we wanted to mention that what Rocio explained wonderfully applies to services provided in Florida. But there are many companies doing business in Florida with employees in Florida, but because they happen to be in Miami, they also perform services outside the United States, sometimes back and forth, flying all the time, or even hire from Florida but doing providing services in other countries in the Americas. Clients and employers should be very, very careful how they handle those situations because they are tricky. Tricky because what law applies. You just listen to Brazil, and if you are a Florida employee, certain benefits and law applies. But if you are spending time in certain places around the Americas, the law of that country also applies, and not only the labor law, but also the tax laws of those countries. That would be a completely new event, a new seminar or webinar. I just want you that the audience to understand that if they have those type of employees,
Mhm.
there are many different laws that interact. And I just wanted to mention that before we continue with the question. Go ahead.
Perfect. Wonderful. Thank you, Juan Carlos. Yes, we'll take that into consideration. Next question that we have. What would be the main advice you would give to a company that is trying to grow its business in Florida or the United States?
Rocio?
Okay. So for me, it would be don't assume that what applied in your country will apply here, and don't assume that what applies in another state might apply in another state that you are, trying to make business. I think it's so important to do your due diligence from the beginning, to partner with the right people, to make sure that you're setting your operations well, because if you do not mitigate risk from the beginning, then later on the company might fail just because of the burden of non-compliance and the costs that come with it. So the main advice is really to do your due diligence and to not assume that you know what applies in any one particular state, because it really changes from one jurisdiction to the other.
Yep.
Thank you so much, Rocio. Next question is, does Florida employers or employees laws applies to expats from third countries that are living in the United States and working here?
Very good question. The answer is yes. The labor laws in Florida are territorial. If you provide services in Florida for an employer registered in Florida, the laws of the United States, for sure the federal laws of the United States will apply. If the residency is in Florida, it's very likely that labor laws in Florida applies to that in a specific contract. And that's the issue that most companies doing business in the States and Florida specifically are having, is that they treat expats in a different way. They treat expats like they are only under the laws of the country, especially in this case, Spain, and there are specific rules that apply in those contracts. But the reality is that once they are working in the States, the labor laws that Rocio explained apply to them. So you either have to have a dual contract, or you have to make sure that your employment contract in Spain is in compliance with the laws of the United States, either having an employment contract from Spain with a handbook in the United States. So a lot of interlocking agreements have to be put in place to make sure you're complying with the laws and the contract that you have for expats.
Thank you so much, Juan Carlos. And now we're talking about that. What are some practical recommendations in that case for setting compensation and rewards systems in the Americas?
Well, number one is making sure you're complying with the federal laws. Number two, making sure you're complying with the local law. Number three, making sure you're complying with the city law. And at the same time, if you want to continue applying the international contract, the expat remuneration executive contract, make sure that contract is not double dipping. Because one of the issues we have with expats coming to Florida or the United States from Spain is that we normally try to keep the employment relationship suspended in Spain, but after the termination in the States, the labor laws of Spain applies, so it has a double dipping effect. Benefits under the laws of the United States, plus benefits of the law in Spain. For instance, how the person is terminated. Rocio explained it that in the United States is employment at will. But if you have and you add in the employment agreement a provision that modifies that employment at will. That's why Rocio emphasized employment not to include something in the agreement that get rid of employment at will, then the laws of Spain will apply. So then you cannot terminate the individual. The individual is going to sue you in the States for benefits under the Spanish law, or sue you in Spain to get restated. So it's a complete mess. And by the way, we are dealing with a case right now in our firm, that specific case of an expat doing business in Florida.
Very interesting. Thank you so much, Juan Carlos, for that. How do you hire employees from Florida to work in the Americas?
All right, good. So there are two ways to do it, directly or indirectly. If you want to do it directly, you can either have an employee under a W-2 in Florida, or an employee localized in the specific country, that's directly, or you can have an independent contractor relationship, 1099s in Florida, working abroad, or an independent contractor agreement directly in the given country. So those are the direct way to do it. Or indirectly, many companies are doing that. You hire an employer of record entity, company, there are a lot in the market, very good. They hire that individual on your behalf, either as an employee in the given country, that's the best scenario, best approach, zero liabilities, or they hire that individual as independent contractor, then you have a minor, depending on the situation, risk related with the misclassification issues in the US and in the local country. It's a tricky situation, very, there are many ways to do it that can reduce the cost and liabilities, but it depends on how you want to proceed with the direct or indirect versions I just explained.
One of the versions that you mentioned, the one with zero liability, the employee
Employer of record.
Employer of record, exactly. And that is something that could be also used in the United States for US companies. Is that correct?
That's right. That's correct. Employer of record is it's actually one of the ways companies are doing business globally, because that reduces your employer issues or risks, not related to discrimination and so on, because we have another issue with this co-employment or joint liability of employers. That's another different issue. But it also helps you with the permanent establishment aspect, like the corporate tax of the company doing business in a different country with not incorporation of an entity in the given country. In other words, very simple, if a company is doing business and hires an individual in the States and have no entity, the United States may claim that the corporation from Spain is doing business in the United States and charge corporate taxes for those for that income. So in order to prevent that, the employer record will help. Same thing with the other countries in the Americas. It's a complicated issue for 1 second explanation, but that's pretty much the essence.
But you mentioned before that there is an option that a foreign company could have an employee here without having a subsidiary in the United States?
Through an employer record, you can have an employee without having a subsidiary or an incorporated entity in the United States, yes.
But only through the employer record, not without.
The only way. Is the only way. If you want to have an employee, you have to, United States, depending on the states, you have to have an entity in order to have an employee.
Oh, thank you. Very, very interesting. That next question. Are there any benefits to establishing businesses in Florida as compared to other states?
Rocio, do you want to take it or do you want me to?
No, I could start and then you can supplement if you like, Juan Carlos. So as I mentioned during the presentation, there are states that we consider a nightmare for employers, like California, New York, especially California. So yes, there is a lot of benefits to establishing business in Florida. And in fact, we have seen a big, a big boom in business in Miami and in South Florida because of precisely that. We do not have nearly as many regulations that impact employers as they do in those other states. So this tends to be a very employer-friendly, state to establish your business in.
Yeah, correct. And beyond that, we have no state tax. That's good advantage. Also, the definition of employee misclassification, independent contractor is kind of more relaxed than in other states, even though federal law will apply for the same. And also Florida has, more flexibility in how incorporate legal entities and how those entities report at the state level. That allows you to have employees outside the U.S. and also, of course, inside the U.S. So if you want to set up your shop in the United States, don't go to California as the first place. Start in Florida will be my best advice, because California it looks like is becoming more European style, more complicated than it should, and Florida doesn't have that.
Okay, wonderful. Thank you so much. Thank you so much, Juan Carlos. Next question. What is the main consideration when terminating employment in the Americas?
In the U.S., go ahead, Rocio, with Florida, the termination issues, and I'll give you a brief explanation of the rest of the Americas.
So the main thing is to make sure that you're not treating people differently because of their protected categories, right? So you're going to want to look, if you're going to fire employee A today, you're going to want to look at, well, how did I treat other employees in this same or similar situation in the past? And you're going to want to make sure that you are treating everyone uniformly, because otherwise I'm going to turn around and I'm going to be like, well, hold on, you just terminated me for this, but Juan Carlos did that same thing 2 months ago and he did not get fired. So uniformity in the decision-making process and in the application of policies is going to be crucial in order to avoid any claims of discrimination or unfair treatment.
Correct. And in the rest of the Americas, in Canada, very complicated process to go, depending if you're a Quebec or other provinces. In Mexico, now it's getting a little bit more complicated, but it's just basically an indemnity and indemnification, no complication on that regard. Same thing with Central America, but if you start with with countries like Colombia, Venezuela, Bolivia, Brazil, then termination gets more complicated. So the main rule is, if you're going to terminate employees, try to have in the Americas, not in the States, clear understanding of what is a just cause for termination in the contract agreement. So you make sure that you can include that termination within the employment contract. If you are not able to do that, make sure you understand how severance packages are calculated. The main issue in the Americas is all benefits you provide to employees are considered salary, part of the compensation for the termination purposes, and severance become very, very expensive. So you want to prevent that to happen in country by country, but try not to add benefits into the salary so the termination payment is not as high, and you have an estimation actually of the cost and not be surprised at the time of the termination.
Thank you so much. Thank you. Next question that we have here. What is the main pitfall you see employers commit when establishing operations in the United States?
Rocio?
So for me, it will be related to what I discussed earlier, which is not doing your due diligence and trying to save cost, at the expense of creating liability. So for example, we oftentimes see employers say, well, I don't have the resources to consult with a vendor right now, to consult with a lawyer right now, or I don't want to make that a priority. And the problem, that is a big pitfall, because then you do not know what you don't know. And then you end up committing mistakes that end up being more costly down the line. So I think that is the main thing I see from employers generally, is that they're not investing in the future. They are being short-sighted in that way.
I agree, and one thing we see a lot is that especially Spanish firms, they want to extrapolate, they want to transfer the way they do things in Spain and put it in the United States. For instance, an agreement to pay severance, leaves for maternity, paternity, and so on, conditions to termination, employment contracts, internal regulations that we call handbooks. So recognition of unions and union rights and the right to associate and be part of a union. So those things, if we extrapolate those from Spain to the United States, you are creating rights that you don't have to create immediately, especially when you are starting a business, because then you are competing with other businesses in the same area that they don't have that. So you're going to be more costly, less efficient if you extrapolate all those benefits. So it's very important that you plan it in advance. Try not to be very, very plain in the benefits you provide, in the policies you provide, and try to apply the minimum necessary under the law. And then it starts, once you understand how to compensate, what benefits, how the benefits work, then start giving more, but not do everything at once. Otherwise, you're going to get trapped in your own decision.
Thank you so much, Juan Carlos. Next question that we have here. Does FORA prohibit an employer from asking prospective employees what they are making at their current job?
No. Florida does not prohibit that.
Good. And next question. Are companies obligated in Florida to have a handbook?
So no, you're not obligated to have a handbook in Florida. However, you 100% should. If you don't have a handbook, then your employees don't really know what the policies are, and the handbooks are a great defense. What do I mean by that? So for example, if now you get sued for discrimination, and one of the things that the jury, the court looks at, the law looks at, is like, well, did you establish in place procedures for reporting complaints of discrimination? Did you put in place policies that will prohibit this type of behavior? And if you didn't do those things, you are way more likely to be charged with punitive damages, which are damages designed to punish you as an employer for not putting in place the appropriate mechanisms to prevent discrimination in the workplace. So are you required? Well, maybe not, but you 100% should. That is one of the key things that you should invest the time and money on at the beginning when you're creating your company, and you want to make sure that those policies are disseminated to your employees and that your employees are trained on those policies, especially in a place like South Florida where it's a melting pot of people and we all come from different places with different idiosyncrasies and different mentalities. We sometimes don't tend to think about things that will be considered discriminatory here in the US. I recently had a case of a manager who just couldn't get it in her head to call an employee by the pronouns that the employee was requesting. So the employee was I'm a he, and he looked like a she, so the manager kept calling him a she, and that created a whole thing, right? So it's very important that we educate our employees and our management on those policies, and we do that with a handbook and we do that with training, and 100% something that you need to be doing.
Thank you so much. Thank you, Rocio. Well, it's time, I guess. So that was our last question for now. So I think we can close here for today. But remember that we will share with everyone the presentation, the contact information of Rocio and Juan Carlos, and also the video. And you will also be able to check the video in our YouTube channel from tomorrow onwards. So thank you, Juan Carlos. Thank you, Rocio. Thank you so much for being with us today. It's been very productive and very illustrative. So we took note of many different things. And thank you so much for your help. Your contact information is down below, and we also will share it in case anyone would like to ask a direct question and they didn't want to share that with the rest of people. And for the attendees, thank you so much for spending this day for us. I would like to congratulate women. Today is International Women's Day. So congratulations to every woman in the world, and in particular the ones that are here with us today attending, and Rocio, that's for you as well. So congratulations. And we hope to see you again in the next event of the Spain-US Chamber of Commerce. You can check in our website our upcoming events and activities, which is www.spainUSChamber.com. So thank you, everyone, and have a great day.
Thank you.
Thank you.
Goodbye now.